reading of the legislative language in this section reveals a number of structural ambiguities, policy tensions, and potential unintended consequences that an experienced critic, particularly one trained in law or public policy, would be quick to highlight. While the stated goals of expanding affordable housing access, preserving long term affordability, and promoting economic mobility are commendable, the mechanisms employed are fraught with definitional looseness, administrative discretion, and misaligned incentives that may undermine both effectiveness and equity. I. Overbreadth, discretion, and the problem of administrative ambiguity. One of the most persistent weaknesses throughout the text is the repeated delegation of authority to the Secretary to determine what is appropriate, reasonable, or necessary. For example, the provision allowing acquisition of housing by a community land trust or cooperative includes a catch all clause permitting action for another purpose determined appropriate by the Secretary. Int. This is an archetypal example of overbroad delegation. It invites inconsistent application across jurisdictions, creates uncertainty for developers and beneficiaries, and opens the door to regulatory capture or politically motivated decision making. A naysayer would argue that such vagueness undermines predictability, one of the core virtues of sound law, and may result in uneven enforcement or selective favoritism. Similarly, phrases such as within a reasonable period of time lack definitional clarity, creating opportunities for delay, manipulation, or litigation. Developers or nonprofit intermediaries could exploit these ambiguities to hold properties longer than intended, potentially speculating under the guise of compliance. 2. Community land trusts, a misguided substitute for ownership. The legislation's embrace of the community land trust CLT model deserves particular scrutiny. While CLTs are framed as a tool for preserving affordability, they fundamentally alter the traditional concept of homeownership in ways that may disadvantage the very populations they aim to help. At its core, the CLT model separates ownership of land from ownership of the structure, typically through long-term ground leases and resale restrictions. While this ensures affordability over time, it also prevents residents from realizing the full wealth-building potential of property ownership. Appreciation is either capped or heavily restricted, meaning residents are denied the primary financial benefit historically associated with homeownership: equity accumulation. Critics would argue that this creates a two-tiered system of property rights, one for market participants who can build intergenerational wealth, and another for low and moderate income households who are effectively locked into a form of permanent partial ownership. This is not merely a philosophical concern, but a practical one. By limiting resale value and equity gains, CLTs may inadvertently trap residents in place, reducing mobility and discouraging upward economic movement. Moreover, CLTs rely heavily on ongoing oversight and enforcement to maintain affordability restrictions. This introduces administrative costs and the risk of institutional failure. If the nonprofit entity managing the trust becomes ineffective or insolvent, the long-term viability of the housing stock may be jeopardized. There is also a democratic concern. Although CLTs are often presented as community-driven, governance structures can become insular or dominated by organizational stakeholders rather than residents themselves. This raises questions about accountability and representation. 3. Loopholes in affordability preservation and exit mechanisms. The legislation includes provisions allowing affordable housing restrictions to be lifted under certain circumstances, such as when housing is no longer financially viable due to unforeseen events. While this may appeduces a significant loophole, the determination of financial viability is inherently subjective and susceptible to manipulation. Owners could potentially structure their finances or claim external shocks in ways that justify exiting affordability requirements. Without strict and transparent criteria, this clause risks becoming an escape hatch that undermines the permanence of affordability commitments. Similarly, foreclosure-related exceptions that preserve certain rights while allowing transfer of ownership create a complex legal landscape that may be exploited by sophisticated actors. The requirement that actions not be for the purpose of avoiding low-income affordability restrictions is difficult to enforce, as intent is notoriously challenging to prove in legal contexts. IV. Erosion of tenant protections and small scale exemptions. The exemption of certain small scale housing, e.g., properties with four or fewer units, from key tenant protections raises additional concerns. While intended to reduce regulatory burden, this carve out may incentivize developers to structure projects strategically to fall below the threshold, thereby avoiding compliance. This creates a perverse incentive. Instead of encouraging scalable, affordable housing development, the law may fragment the market into smaller, less regulated units. Tenants in these properties may face weaker protections despite being equally vulnerable. Misallocation of workforce development resources. The economic opportunity and pathways to independence cohort and related job training initiatives reflect a broader policy assumption that structured training programs will lead to improved employment outcomes. However, a skeptical analysis would challenge this premise. Labor market data consistently shows that higher paying jobs tend to prioritize demonstrated work experience over participation in training cohorts. Employers often view such programs as insufficient substitutes for real world experience. As a result, participants may complete training without meaningful improvement in job prospects. From a cost benefit perspective, the funds allocated to cohort based training might yield greater returns if directed toward job placement services, wage subsidies, or direct employer partnerships. These approaches align more closely with actual hiring practices and reduce the friction between training and employment. Additionally, cohort models can suffer from selection bias and attrition. Participants who complete the program may already possess characteristics that make them more employable, while those most in need of assistance may drop out. This undermines the program's effectiveness and distorts outcome metrics. V. Structural barriers to homeownership ignored. Perhaps one of the most significant omissions in the legislation is its failure to address non monetary barriers to homeownership. While financial assistance and affordability mechanisms are emphasized, other critical factors are largely ignored. Short or unstable work histories, for example, can disqualify applicants from mortgage approval regardless of income level. Similarly, criminal records, even for nonviolent offenses, can limit access to housing due to background checks conducted by lenders or housing providers. Civil law issues such as prior evictions, judgments, or poor rental histories also play a substantial role in determining eligibility. These factors are often more determinative than income alone, yet the legislation does not meaningfully engage with them. By focusing narrowly on affordability, the law risks misdiagnosing the problem. Housing insecurity is not solely a function of price. It is also shaped by creditworthiness, legal history, and social capital. Without addressing these dimensions, the policy may fail to reach those most in need. 7. Incentive misalignment and administrative burden. Finally, the legislation introduces a complex web of reporting, compliance, and oversight requirements. While accountability is essential, excessive administrative burden can divert resources away from actual service delivery. Public housing agencies participating in demonstration programs are required to track extensive metrics, from eviction rates to voucher utilization. While valuable for research, these requirements may strain smaller agencies with limited capacity. Moreover, the ability to reallocate funds or penalize jurisdictions for noncompliance introduces uncertainty that may discourage participation. Agencies may become risk averse, prioritizing procedural compliance over innovative solutions. Conclusion. In sum, while the legislation aspires to address pressing housing challenges, it is vulnerable to critique on multiple fronts. Its reliance on vague standards and administrative discretion creates legal uncertainty. Its promotion of community land trusts substitutes long term affordability for genuine ownership, potentially limiting wealth building opportunities. Its workforce initiatives may misallocate resources away from more effective employment strategies, and its failure to account for non financial barriers to homeownership reflects an incomplete understanding of the problem. A rigorous adversarial analysis suggests that without substantial refinement, the law may not only fall short of its goals, but also produce unintended consequences that entrench rather than alleviate housing inequality.